Hi, thank you for tuning in to my YouTube channel. I am Jack, the immigration attorney, and in this video we're going to be talking about 5 things you need to know if you're marrying a green card holder. So what is the difference between marrying a green card holder and marrying a US citizen? This is a question I get asked a lot. Well, obviously, if you marry a US citizen, your application for a green card will be processed much faster than if you marry a green card holder. So here are a few things you need to know when you're marrying a green card holder. First, your green card is going to take roughly about 2 to 3 years to complete because of something called the visa bulletin. Because the green card spouses are under category F2A, and F2A generally has a processing time, which is like a waiting time to get the green card for about 2 years to 2.5 years. This period of time can be shortened sometimes, but over the years, depending on how many people apply for this benefit, the processing time is generally about 2 years or more, sometimes even 3 years. And during this time, number 2, if you want to wait in the United States, you have to maintain legal status. A lot of people come here on a student visa and then they just go through school and then wait for the petition here, or they come here on a work visa, or they come here on an investor visa or some kind of other status that allows them to wait in the United States. Because filing the green card application when your spouse is a green card doesn't give you the right to live in the United States. It doesn't give rights to status, which means that if you want to stay in the United States, you need to have separate status. Now, the third thing you need to know is that the green card spouse needs to hold on to his or her green card all the way until the application is approved for you, which means that the immigrant visa is approved or the adjustment status is approved. This means that if the green card spouse decides to move outside of the United States and start living outside the United States, he or she runs the risk of losing the green card for not being here, and that would in turn jeopardize your green card application. And number 4, if this green card application were to reach the end, there is an affidavit of support requirement. An affidavit of support requirement requires the petitioner to live in the United States and establish domicile. So if the petitioner is living outside or has lived outside for quite some time and doesn't have any connections or employment with the United States, it might be difficult to file for adjustment of status or consular process because of the affidavit of support requirement. And if the petitioner is not able to establish domicile in the United States, domicile meaning where they live, then even with the joint sponsor, sometimes, oftentimes the consulate or USCIS will not accept the affidavit of support because the petitioner needs to file an affidavit of support and the joint sponsor needs to file one too. So if the petitioner is not living in the United States, cannot establish domicile, even if you have a joint sponsor, it does not work for the immigrant visa or adjustment of status. So these are the type of pitfalls that you need to know when you marry a green card holder, and plan your wait for the visa number to become available, and check the visa bulletin every month to make sure that you can plan ahead and know when to move back to the United States if the petitioner is living outside of the United States, and also when to get employment and tax returns and all the W-2s in line, so that when it comes time to file the affidavit of support, the green card spouse is able to do so without any problems. If you have any questions, please feel free to reach out to me and I'll be more than happy to answer them for you. Thank you. Have a good day.